Thanks, Jason. Let's talk a bit about genetics. Clearly, as medicine is moving and biomedicine is moving into the world of being able to look at individuals' genetic makeup and their predisposition for uh, significant diseases, is that information that's highly sensitive. And how is HIPAA going to treat that? Well, the federal government, I think in 2008, came out with a genetic information non-discrimination act, and they kind of let it sit around fallow for many years, and they kind of said, we don't really know how this is going to work out, but we want to protect a person's genetic makeup for being used in the marketplace for employers or health insurers. And so after a few years, they said, here's what we'll do. We'll have the HIPAA rules kind of generate the rules for how this new GINA Act is going to work. And that's just what happened. So in 2013, when the new omnibus rules, HIPAA rules came out, all of a sudden now we have an understanding of how this GINA is going to work. GINA works along two different tracks. One is an employer-employee track, and one is the health plan track. The employment component basically says that employers may not request or require or use genetic information in their hiring decisions or for other discriminatory purposes. I mean, that obviously, I suppose if an employer wants you to take a urine test before your employment in order to determine, drug or alcohol problems, they can't also ask for some genetic test to see if you're predisposed to contract cancer in 3 years, and therefore they won't hire you. So that's illegal. The other side of the GINA law is the health insurance component, which basically prohibits insurers from using your genetic information in setting premiums or underwriting or in determining eligibility. Now, again, the Affordable Care Act kind of did a number on the pre-existing condition requirement, and let's face it, an insurance company back then could use your genetic information, or theoretically they could use your genetic information or that of your parents, or even up to your great-great-grandparents, up to the fourth degree of blood. They could use that information to determine whether or not you would be a good risk for their underwriting pool and not let you come in and be an insured party. Well, fortunately, Obamacare doesn't permit those types of discriminations anymore. But we still should be aware of what exactly the GINA rules do. Basically, they say that a health care plan, other than, very interestingly, a long-term care plan, but not a nursing home care plan. But if you have a long-term health care plan, arguably can use genetic information to determine underwriting or predisposition. But other than that, insurers may not use genetic information in determining the appropriateness of either a treatment or, say you're seeking benefits, and let's say the doctor says, well, let's have a stent for your heart, and the insurance company can't say, well, we've seen by their genetic disposition they're going to die of X in 6 months anyway, so we're going to deny coverage for the stent. Well, I mean, that's illegal. That can't happen under these new rules. And there's definitions of what's genetic information, whether derived from a test or whether it's manifested. For example, it's not illegal for me to say, well, my great-grandmother, my grandmother, and my mother all died of breast cancer. And, that in and of itself is not, genetic information as long as the physician's looking at me, and assuming I were female and were susceptible to breast cancer, they couldn't, if they look at me and have that knowledge in the back of their mind and they make their own determination whether or not that family predisposition is there, well, that's not genetic information that's impermissible for using under the law. But if my physician only looked at for example, my blood work and made that determination, or my DNA work more specifically, and determined that I was, had the marker for predisposition for breast cancer, and they didn't look at me at all, the patient at all, well, that is genetic information, notwithstanding the family history they've got behind them. So that's kind of the general rule. You just know that there is a protection against using your genetic disposition and your genetic family history from employment decisions and in treatment and insurance coverage decisions.